court tonight, which is index number SC002027-24, in the matter of Terrell Taylor versus Jamaica Medical Center Pediatric and Martin Clear Water and Bell LLC. If we could please have the parties vote. The claimant on my right and the counsel on the left. And if we could please have parties in addresses, which is for the claimant, his name and address, and for the attorney to give his appearance. Counsel first.
Brandon Fernandez from Martin Clear Water and Bell on behalf of Jamaica Hospital.
Okay.
Raise your hand. Do you swear or affirm that the testimony you're about to give is the truth and abundance of the perjury?
Yes.
Thank you. State your full name and address.
Terrell Taylor, 174-22, 125th Avenue, Jamaica, New York, 11434.
Oh. Counsel, if you could kindly clarify, according to the caption here, it's unclear. You're appearing for Jamaica Hospital, the Jamaica Hospital entity, or your firm is actually a party, the way it's.
We're appearing on behalf of Jamaica Hospital Medical Center, Dental Clinic, and Pediatric.
Okay, all right. If I showed you the caption, you'd understand why you're making that inquiry. Okay? All right. So, and we need Mr. Taylor sworn. Okay?
It's done, Judge.
Okay. So, Mr. Taylor, you're suing the Jamaica Hospital Medical Center, Dental Clinic, and Pediatric for $10,000 for medical malpractice. Matter was conferenced on January 15th, which is quite a few months ago. It is marked final for trial tonight. And Mr. Taylor, why do you believe you're entitled to $10,000 from Jamaica Hospital?
First and foremost, Your Honor, I didn't see your name out there posted up, so can I just write your name down?
Yes, my name is Joseph Kasper, with a K.
K-A-S?
That's correct.
What's the rest?
Kasper.
Okay. Joseph is J-O-S-E-P-H.
That is correct.
I don't know if it's necessary to speak about the facts of the case. I did it several times already. I just want this case to be scheduled for a jury trial. And I have a question, if I may.
I can't give you legal advice, but I can try to answer your question.
Okay.
Within my authority.
Under New York State Constitution, Article 1, Section 2, that guarantees me the right to a jury trial in all cases, all civil cases. Well, I've read that. That's a part of the Constitution. So I just wanted to, I don't know if you want to confirm that, but
Sir, to the best of my understanding, you waive your right to jury trial by appearing in small claims court because it is a statutorily created, limited jurisdiction where matters within the jurisdictional amount ought to be resolved on an expedited basis. So, if you want to sue Jamaica Hospital Medical Center Dental Clinic, Pediatric, and have a jury trial, you're welcome to withdraw this matter and sue within the civil court proper. Otherwise, you are not entitled to a jury trial in small claims.
Can you cite the law that governs that?
Sir, I don't have the time to do that right now because there are a number of other people here. But if you want me to recall this matter and have somebody who's ready to proceed with trial right now, rather than discuss the jurisdiction of the court, I'll gladly recall the case. What's your pleasure, sir?
I'm not discussing the jurisdiction of the court. I'm just I just wanted to know what you was referring to. Does that supersede the Constitution? Because it's not the Constitution that you're referring to. So whatever you're referring to, is it possible for it to supersede the Constitution? Because under Article 1, Section 2 of the New York State Constitution, I'm guaranteed the right to a jury trial in all cases.
Sir, you're not guaranteed a jury trial in a small claims matter. But counsel, do you have any thoughts on this matter?
Your Honor, if I may, at the last time we were here, Judge Mark Kagan issued an order, and it was clear that he was either the claimant was either supposed to show up ready to proceed with trial or withdraw his claim. One of the two, and he was already apprised. We've been through this same thing last time, so I'm just.
May I have the order? Show it to the gentleman.
I have it.
Okay, then you don't need it. Court reads into the record the June 18, 2025 order of the Honorable Mark Kagan. Plaintiff's motion for an adjournment to 10/30/25 is granted. So, sir, this matter was adjourned tonight at your request, according to this order.
Right, I never requested an adjournment. That's why, I guess that's why Mark Kagan is not present today, because I filed a complaint against him. If he adjourned this for a trial, then he should be here today, but I filed a complaint against him.
Sir, the rules of the court are such that
I never even...
Sir, as a matter of fact, actually, Judge Gunn was scheduled to be here tonight, but...
I never filed a motion for an adjournment, though, so that part is, is false information.
Sir, you have to give your adversary an opportunity to speak, okay? He put this order up. So, I read from this order. The claimant waives his right to a jury trial by commencing a small claims action, notwithstanding other orders of the court. The adjournment is final. On the new date, either the claimant will proceed with the trial or withdraw this claim and pursue a claim in the general trial court where a jury trial is an option. So, sir, there's something called the law of the case. This order is the law of the case. Did you appeal this order by any chance?
You missed a sentence in this order as well. Can you read that into the record, please?
Sir, I'll read the entire order. Claimant's motion for an adjournment to 10/30/25 is granted. Pursuant to lower, looks like Court Act 1806 and 1806A, the claimant waived his right to a jury trial by commencing a small claims action, notwithstanding other orders to the contrary. The adjournment is final. On the new date, either the claimant will proceed with the trial or withdraw this claim and pursue a claim in the general trial court where a jury trial is an option.
Okay, Your Honor. Pursuant to Lower Court Act 1806 and 1806-8, when I looked that up, it has nothing to do with waiving your right to a jury trial. It has nothing to do with that. And that's what this judge, this was his reasons for saying that this is the law that he's referring to, act that he's referring to when...
Sir, you will not get a jury trial tonight. There are no jurors available.
Well, it could be adjourned. I don't have a problem. I didn't want a bench trial. I put in for a jury demand, you know, they was served with a copy of the jury.
Sir,
I'm just asking.
I'm going to not let you waste any more of the court's time. Do you want to proceed with trial, or do you want to withdraw your case?
So let me
That's
just
a
get
yes
an
or no
so can I get an
question,
understanding before I answer that? So you said there's no jurors here, as if I can have a jury trial. But if you're saying that I have no option, it's either a bench trial, or what else did you? What was my other option?
Sir, you either proceed with trial, or you withdraw your case and refile it in the small claims court.
Also, I'm forced to move forward with a bench trial, and I have no choice because I'm not withdrawing this case. So you're forcing me to.
Sir, you're not being forced to do anything.
Yes, you
Do
are.
you want to proceed or don't you?
We can proceed with it because I have no option. I'm not going to withdraw. We can proceed with a bench trial.
Feel free to do so. Call your first witness.
I don't have any witnesses.
Counsel?
I have my witnesses here, but I'd like to hear his case first.
He says he has no witnesses.
Okay.
Where's the evidence? Where's the testimony?
I have paperwork. I have paperwork right here as far as the evidence, but I don't need a witness to prove my claim.
Sorry, I don't know what you have.
No, I'm letting you know. I just have paperwork right here. This is the office visits to Jamaica Dental. It shows what was done, and yeah. If you want me to explain, I will.
It's not up to me for what you want to present to the court. What do you want to do with those papers, sir?
Okay, so this is the first paper I want to hand up is the visit date was January 3rd, 2024. It was for phlebotomy. I really can't pronounce this thing, but it was a procedure done on tooth number 19, and it clearly says here that Terrell Taylor is aware.
Sorry, I have to interrupt you. You are reading from a document which is not in evidence, and that is not permissible under the law.
It's not in evidence?
It's not in evidence. You can't read from a document that's not in evidence.
There was a subpoena for records. This is how I got this document. So y'all have the entire record. Actually, the court has it. I made a copy of it. Y'all have these documents right here.
What do you want to do with it?
But I can hand it up to you as well. But you have a copy of the record of me.
I don't have a copy of anything.
The court does. So I was reading it. So I was gonna hand it up after I read it. Would you like me to hand it up before I read it? I'm trying like.
Sir, you can't read it until it's in evidence. You can tell me you have a document that you want to show me, but you have to show it to your adversary first.
This is a document. There's three of them. Here's all three of them. They're in order. First, second, and third. Your Honor, quick question. Can you look into the system and see if there was a subpoena filed and it was for records regarding this case?
Sir, it's not my duty to look into whether you have documents.
My only objection to those is just random pages from the chart, so if I just, we'll find out.
Counsel, what's your objection?
My objection is he's submitting just random pages from the chart, and just want to note that that's not a full chart from Jamaica Hospital, but it appears that it is some pages from the Jamaica Hospital chart. Just wanted to make that on the record.
Counsel, if your only objection is it's not a complete record, what's the basis of your knowledge of that?
Oh, it's not certified, and I'm not really sure what purpose he's offering it up for.
It's not a certified record.
This isn't a certified chart.
Objection sustained.
Question, Your Honor?
Yes.
I know the courtroom got quiet, so, objection sustained, what does that mean again?
Sir, it means that the document will not be admitted into evidence because you don't have a certified medical record there.
So, you're not gonna, look into the subpoena that was filed in this case, because these are the same records that I got
It's
from.
not the court's duty to,
Oh my God,
Determine
this is
whether
why I
you're
don't
seeking-
like doing jury trial. What are you
sir,
what are
if
you
you want
talking
to
about?
proceed with this
What
matter,
are you
please
talking
don't.
about, man? It was a subpoena filed. Y'all have the records. This is a copy of the same records that was sent to the court. And you talking about it's not a certified copy. What are you talking about?
Sir, please take a seat in the audience.
What are we doing?
This
A
matter will be
second call?
recalled. Sir, this matter will be recalled. Please take a seat in the audience.